Hi guys. Hello, hello, hello. How is everyone doing today? So, I have a topic today that I decided to discuss this because of a consultation I had. So, I'm just going to wait for a few more people to come in. And if you join us in here, please let me know where your location is. Say hello. It's always nice to have some communication so I know I'm reaching out to people. So, for those who do not know me, my name is Odunlami. I am an immigration attorney from New Jersey. My law firm serves clients in all 50 states um, with immigration matters, primarily family based, humanitarian, removal, defense. So, if you have an immigration issue, please feel free to call my office, 973 993 1900, and press 1. That's for, that will take you to the person who will assist you. Hi, Amarjit. How are you? Nice to meet you. Thank you for joining me. So, guys, so this happened recently, and I just thought I had to alert you guys as to this information because this is so important. So, I had a consultation with a client who had filed a petition for her unmarried son. She was a green card holder at the time she filed the petition. And so when she filed the petition, because she was a green card holder and because he was over the age of 21, he was on what we call a preference. So when you're in a preference, it means that there's no visa immediately available. And that's what typically leads to the long lines. When you've heard about siblings filing for each other. It takes like 15 years, maybe even 20 years, depending on where you're from. And so she had filed for her son. And finally, she got a letter from NVC, National Visa Center, basically telling her that her son's priority date had been reached and it was time to move to the next step. And she must have waited maybe 8, 9, 10 years because, she was a green card holder filing for a child who was over the age of 21. So while talking to her and during the consultation, I found out that her son had gotten married. She's now a U.S. citizen, but he had gotten married before she became a U.S. citizen. And that means that petition is dead. That's what it means. And this was just it was so horrible to tell her this because basically she's going to have to start from scratch now filing for him as a U.S. citizen, filing for a married child, which the priority date is so. I mean, I think they're working on cases from late 2000, if I'm not mistaken. Let me see what the visa bulletin says because now she's let's see, just give me a second. I'll see what the visa bulletin for August. Because you guys know what the visa bulletin is. It basically is something that changes every month and basically tells you what cases they're working on based on what country you're from. So now that she's naturalized, she is an F. Her son is now in the category of F3. So she is a U.S. citizen filing for her married son. And F3, they're still working on cases from 2009. They're working on cases from 2009. So basically all those times that she waited 7, 8, 9, 10 years for the priority date to be reached, then the priority date is reached only to find out that now she's married. USCIS, now that her son is married, and he got married while she was a green card holder, that petition is dead. She's going to start from scratch again. That's really horrible. So it's very important that you guys share this video. If you know somebody who is a green card holder filing for a child who is over the age of 21, that child has to stay single until that petition is completed. Because if you get married, then that petition is mute. So let me go over how getting married can affect your petition. I had another case where my client's father had filed for her. She was single, and she was under the F1 category, which is unmarried sons and daughters of U.S. citizens. So she was abroad. Her petition priority date was reached. She got called in for an interview. She got everything was processed, and she was ready to come into the United States as a green card holder. But then she got married just before she left. And the laws say that you have to keep that same status until you come into the United States. So by getting married, she had now violated the status with which she was approved. So what that means is that, first of all, USCIS didn't catch on, but when she applied to naturalize, that was when they found out that she had gotten married after she was, approved for the green card, but before she came into the United States, before she was inspected as a green card holder. And so they denied her naturalization, and is currently still denied and she's lucky she didn't get put in deportation proceedings, because typically that would be what would happen. But when she came to my office, we represented her. We filed, we appealed the naturalization, and we went before an officer, and luckily for her, they let her have her green card. So today's topic is really, I just want to talk about the preference category, how your family member can file for you, and the things that could jeopardize that filing. So the funny thing is, if she had come into the United States as a green card holder and turned back and left the next day, or had just come in and filed for her spouse as soon as she got in, it wouldn't have been a problem. But what I meant is, if she had come into the United States, right, and turned back and went back and gotten married, it wouldn't have been a problem. But you cannot change the status with which you were approved before you come into the United States. So that was a problem, but luckily for her, it wasn't a problem that denied her of her LPR status, but it's a problem that denied her naturalization application. And other ways that marriage can, cause your case to be denied are cases like VAWA, Violence Against Women's Act. If you apply for VAWA, you cannot get married before your VAWA case is approved. If you get married before your VAWA case is approved, you have abandoned the petition. It must be denied. If you file special immigrant juvenile status, which is another petition type, and you get married before the SJIS is approved, the same thing, it's denied. So if you want to get married and you have a pending petition, you really should take the time to talk to an attorney to make sure that getting married will not, upset the pending petition. So let me talk about the categories of filing for family-based immigration. So the immediate relatives are that category where there's a visa immediately available. So that's the spouse of a U.S. citizen, the child of a U.S. citizen who's under the age of 21 and who is unmarried. Note this, unmarried and under the age of 21, because if you're married, even if you're under the age of 21, you're not an immediate relative. So you see how marriage changes that dynamics right there? So you have to be unmarried and single to be an immediate relative. Then the third category is if you're a U.S. citizen who's over the age of 21 and you're filing for your parents. Those are immediate relatives. That category, three of them, there's a visa immediately available. So when you file, if you're in the United States, you can file the I-130 and file the adjustment of status at the same time. If you are abroad and you're doing it by consular processing, so you would file the I-130 and go through the NVC process. Now, talking about preference, the people who are on a preference are people who do not have a visa immediately available. And those are the F1 category. And when I say F1, I don't mean student F1, I mean F1 on a preference. Those are unmarried sons and daughters who have a U.S. citizen parent filing for them. So in immigration, there's a difference between sons and daughters and children. Sons and daughters are over the age of 21. Children are under the age of 21. So If you're unmarried and you are over the age of 21 and you have your US citizen parent filing for you, you're under the F1 category. And that typically has 23,400 visas available in any given year. And that gets, used up really fast. So once that's used up, everybody else is on the wait list. So if you look at the visa bulletin, which, as I told you, changes every year, you will see that in most countries, they're working on cases from 2015. Your priority date is the date you submit your application, right? That's the date that is listed as your priority date. So they're working on cases that USCIS received January 1st, 2015. That's for people who live everywhere but China, India, Mexico, and Philippines. If you live in China, you still have the same priority date based on the bulletin I'm looking at. If you live in India, you still have the same priority date, which is January 1st, 2015. But if you live in Mexico, they're working on cases from April 2001, April 22nd, 2001. Can you believe that? And if you're from the Philippines, they're working on cases from March 12th, 2001 as well. So it's really important that you don't do anything that puts you in a different category, because if you get married, for instance, if this person who's on F1 who has a priority date, well, priority date is when they file, but they're working on cases from January 1st, 2015. If you're on F1 because you're married and you're the son or daughter of a US citizen, if you get married, you move to F3. F3, from the same category, they're working on cases January 9th, January 8th, 2009. So you see the difference from January 2015 to January 2015 to January 2009. So why would you, if just getting married puts you in a category that makes your wait longer? So you want to be careful about that. Now, F2A are spouses and children of permanent residents. And I told you that children are under the age of 21 and single. So F2A are permanent residents, spouses, and permanent residents' children. Now, F2B is unmarried sons and daughters of green card holders, right? Permanent residents. So if you're over the age of 21 and your parents files for you as an LPR, you are F2B. So F3, like I said, is married sons and daughters of US citizens. And F4, which is the most delayed category, is brothers and sisters of adult US citizens. That one, the wait, depending on where you're coming from, what country you're from, it could take up to 15 to 22 years. And so it's important that before you decide to get married, if you have a petition pending, or even if you don't have a petition pending, you might want to know where getting married would place you, because nothing says you cannot have children, but getting married is a step that has consequences. So let me talk to Alaji real quick. Let's see. Alaji says here, thank you for your assistance and prompt response. You really went the extra mile and did more than enough to help me secure my working permit, travel documents, and social security through VAWA. You're very welcome, Alaji. I don't know if anybody has any questions, but I just want to put that out because I think that a lot of people are not aware that getting married, really affects their petition. So you want to be careful about what you do. So I'm looking to see if there's any question. No questions. Does anybody have any question? No. I think that'll be it for today then. Let's see. Yeah, so that'll be it for today, guys. I just wanted to come through and just let you guys know that, if you know somebody whose parent is a green card holder and they have filed for them and they filed for them while they were single, getting married causes that case to be revoked or denied, because there's no category for a green card holder filing for a married child. There is no category for a green card holder filing for parents. So you just want to be careful about that. So Chidima says, how long does it take after being approved of your VAWA and you have sent in your medical, but yet to get your I-485 approved? How long does it take to get your green card? Chidima, that's a really great question, but it really depends. We're seeing an average of 3 to 5 months. Some people get it right away. Some people it takes longer. I can't really explain that. I think it just depends on the field office and how fast they're moving on those cases. That's really it. Okay. So guys, thank you for joining me. I'm gonna hop out now, but I will be back next week. I want to go over humanitarian types, cases, VAWA, U visa, SJIS, and T visa, which my firm does a lot of those cases. And I want to just go over it because I get questions on my DM about those case types. So I'll join you guys again next week, and if you have any questions, please line them up so we can talk about it. Take care and have a great weekend.